So, colleagues, I suggest we resume our work, and I'd like to thank the Minister of Justice once again for this opportunity to exchange views and experience. Our session is also relevant and topical because next year, or this year in October, November, we'll have the 6th conference of the UN members combating corruption, which is a major event held internationally. So this will be held for the 6th time, and that's the turn of Russia. So we are preparing the conference now, and I believe that this particular event will become a kind of a prelude to the forum, which will take place in October, November in Moscow. So I'd like to stress the fact that we started combating corruption in 2008, and the process has been underway since then, and we identified a number of problems, among which a major one is that we should have a better coordination, and thus the decision by the President last year, a specialized agency was set up to counteract corruption. Oleg Plakhoy, the head of the agency, was going to come, but he cannot be present here at the moment. But we have other people from the agency, Mr. Belinsky in particular, who will have the floor, and he will share his vision of the work combating corruption, and in particular coordination, which is required. Friends and colleagues, I'd like to thank you for the invitation to speak here. We are discussing a very important issue, and though corruption is usually associated with civil servants, it is no less important for private sector and for business, because it is spread there as well, because of the conflict of interests in place. And usually there is a conflict of state interests and the interests of owners and businessmen, which may result in bad negative consequences. Thus, corruption in state procurement, bribes, and in particular in the effort to get all kinds of permissions, regulatory documents, etc. So the corruption costs are to be compensated at a later stage, which entails economic and other consequences, so that people may even die and infrastructure may be destroyed. So the consequences may be dire, and we should combat corruption, and we should do it systematically, and we should take measures, which has been done of late. It requires cooperation by the government and by business. So if cooperation is in place, then we can be successful. Our department deals with these issues, and under the decision of the President, and in particular by the council set up under the President to combat corruption, which took decision to set up such an agency within the administration of the President. We analyze processes underway in our country. Also, we analyze legislation. Monitoring is being held by the state bodies and local government, and the results of the monitoring, assessing the work of the government agencies, showed in 2012 that the major corruption risks are shifted towards economic corruption and business or entrepreneur activities. Thus, we orient our work in this direction. We also make more active our work in the presidential administration, analyzing the sources of income and expenses of top officials of the country. A number of questions have been raised here, but answering them, I can stress that we are no special service. We are not investigating things, but we are organizing measures to counteract corruption. And also we see to it that all the bodies involved coordinate their activities. We provide assistance in terms of international cooperation, and as the Russian Federation is a party to all major international treaties aimed at counteracting corruption, we are members of all international bodies in this area. We use international experience and introduce it in our legislative system. A number of regulations contained in conventions are very specific, and we include them in our legislation based on the decisions of international organizations complying with the major principles of the legal system. Still, the efficiency of the system is assessed very highly by international experts because we are very consistent in our combat against corruption. So we have taken a lot of decisions in this area. We streamlined the criminal liability, and Article 28 of the Administrative Criminal Code envisages punishment and sanctions in respect of legal entities. And this is just the beginning, because we envisage a number of measures to improve efficiency of this regulation. Another important area is institutionalization of municipal bodies, local authorities, and foundations combating corruption. Also, it concerns municipal services, and we have a new law on state procurement, as you know. So we are working in this area as well, because a lot depends on economic regulation measures and providing for transparency of all the processes, accounting and reporting, and in particular those measures which are taken to put an end to offshore schemes of Russian businesses. Also, we aim at improving the efficiency of enterprises and their organization structures, including raising the salaries of the employees, because this may be a cause of corruption. We are exercising control over expenses of public officials, and they're prohibited from using foreign accounts and so on. Those who work in state corporations based on federal laws, and they implement the tasks set up by federal bodies, they have to inform us of all the deeds that may relate to criminal activities. So we are just in the beginning of this work, and still we have results which prove that it is efficient, and the World Bank rated our work rather highly. We believe that we are going in the right direction. We should also be very principled in terms of approaching businesses as far as corruption is concerned, and cultural, ethical, and other aspects in business corruption are of great importance. So we should develop and implement the national standards which reflect the specificities of our legal system. We have a national plan combating corruption, and Article 13.3 envisages that businesses must take measures to counteract corruption, or to prevent corruption even, though it may be not easy, because we should change mentality and business paradigms. It is envisaged to provide assistance to business in terms of methodology, which may be provided by the Ministry of Labour. Also, associations of entrepreneurs which will be monitoring the implementation of the norm, and the major associations, including the Chamber of Commerce, All Russian Association of Pora, Delovaya Rossiya, the Russian Union of Entrepreneurs and Industrialists as well. While individual businessmen aim at reducing expenses through legal means, the associations and business community are interested in reducing corruption and improving free competition environment. And there is demand in society for putting an end to corruption. Thus, we adopted an anti-corruption charter for Russian business, which shows that the grey shadow economy is somewhat coming to an end. Also, culture and zero tolerance in our society is also indispensable. We must cooperate with public associations and expert communities. We get involved in this work. We have a special expert council which includes scientists, researchers, public figures, etc. I think that half of the membership is represented in here at this session, and we are planning to have the first meeting on the 1st July, and we will discuss anti-corruption education there, which is a key to counteract corruption. We should have a breakthrough in educating our civil servants and citizens at large, and that we should move towards progress in this area. We should also raise the awareness of the population at large in terms of corruption combat. We know that businessmen take certain steps in this direction, and they should be well aware of the risks of violating the rights of entrepreneurs and protecting their own rights. And we see that certain tasks are of dual nature. They are business and legal at a time, and we should improve the legal culture of citizens, which is important. It's a matter of legal literacy of the population, and I hope that this forum will have a great contribution made to this work, but we must be more specific in our activities, and I hope for success. Thank you for your attention. It's true, coordination and stage-by-stage development is of utmost importance in combating corruption. And I'm aware of the regulations you mentioned, which serve as a basis for your agency. You missed one thing, that is a kind of a cleanup of the state bureaucracy, because we expanded our approach of late, and we have good results, because society seems to be expecting very large cases with millions of rubles involved and so on. But I think that routine work is more efficient in terms of civil service work. And we should analyze the mechanisms which should prevent people with corruptive mentality taking up positions in civil service. And we should have not only restrictions and limits, we should change mentality at large, because people should understand what it's all about. And one of the issues is the problem of gifts, and corporate gifts in particular, though it seems to be negligible. But what should be done with those gifts? Well, certainly we can impose a ban on taking gifts, but there's another part too, that is societal people who bring gifts and give gifts to civil servants. So what should they do? How they should respond to it? Should they say, go away? No, I'm not going to take it. But it may be counterproductive, and taking into account the specific features of this country, different cultures and social groups, while it may result in the emergence of enemies as a result of such behavior. But we should take into account such things. We should have a lot of audit in civil service, and we know that a lot of people are really grateful to us for all those checks and audits, because they thank us for these steps. But we will punish you if necessary, so don't take offense. So this is one of the tasks of the new agency, which has been described here. Besides this, we have a lot of other topics on the agenda, and Mr. Mitr was right saying that the state bodies, the civil service, is the major agent in the process. We have civil society bodies, we have a lot of guidelines provided by them. We have a lot of instructions by our ministers dealing with lobbyism, involvement of entrepreneurs in combating corruption. And this is the Minister of Economic Development who is involved in it, and the head of a department of the Minister of Economic Development will speak now, and he will provide more details to it.
Добрый день, уважаемые коллеги. Я бы действительно тоже продолжил или начал бы, вспомнив тот анекдот исторический, который господин Дитрих сегодня вспоминал.
By recalling a historical anecdote about Frederick the Great and about how he changed the paradigm. Of course, it was the Frederick II who changed the paradigm, but the initiative was with a private miller, the private business. So in my opinion, when we discuss this topic, so far, this attitude towards how things are must change for the business community. And it's quite obvious that you have to demand from civil service the compliance with the area that we regulate. In that respect, we come back to the issue that has already been discussed here. What's important, ethics or regulatory measures? Well, given the World Championship is underway, I would provide an analogy. What's more important in football, defense or forwards, defenders or forwards. Both are of importance. Even if you have good regulatory measures, if you have good enforcement, which is a rare thing, because although the laws may be written very well, it's more difficult to enforce those laws. But even if you have all that, but if the values that are translated in the regulations are not shared by the society, there will be no effect. And vice versa. Even if the regulation is not enough, if there are no legal prohibitions, but the public conscience is high enough, another problem arises. If people arise in the society who do not share those ethical norms, there may be serious short-term incidents. So this balance is very important, and we think that on a national level, serious attention must be paid to the formation of values and change of practices and to ethical issues. Apart from that, the balance between regulation, well, when we conducted anti-corruption review, expert review of legal documents, and you know that one of the indicators there, which usually provides a negative conclusion for legal documents, is the absence of rules and too much arbitrariness by the civil servants. I really heard it with envy from Dietrich when they kind of really find a supplier, if they really need some supplies, bypassing the accepted procedure. We are too much regulated, we're over-regulated, which really is a negative issue. But this balance also depends on the quality of civil servants. If we believe them, if we understand that honesty prevails, we don't have to regulate them so much. The less we trust them, the more they must be regulated. Now, back to the business. I think what I said applies to business too, and it's very important that back in 2012, and that was during the Sochi Economic Forum in the presence of Dmitry Medvedev, where we signed the charter of the Russian business, an anti-corruption charter that had been developed by the Big Four, the RSPP, the Russian Entrepreneurs Union, the Chamber of Commerce, and the Business Russia organization who represent the interest of SMEs. On the one hand, this was a declarative document. It contains 12 principles, which those four organizations undertook to promote among the business community, and they also promised to abide by them. The mechanism of the charter provides that though it has been signed by the four leaders, by organizations, by legal entities, by economic entities, that charter may be joined by others, and the purpose of the charter is to stimulate others joining this charter. There are very few formalized procedures there. There is no rigid procedure for assessment, and it provides for a voluntary performance. I can inform, after 2 years of the charter's existence, that the register of organizations that joined the charter numbers 131 organizations. There's a lot of public organizations, subdivisions of the Chamber of Commerce among them, but probably you would be interested to hear some well-known names that are on the charter. Severstal, for once, joint stock company. Alrosa company, for example. Then such companies as Norilsk Nickel, Kamaz, VTB Bank, Megaphone, Rostelecom, UTR, and those are big and well-known companies. So really, some companies believe it's important for them to join the charter, to declare their commitments to the values of that charter. We have a special work group involving business community, where we often discuss the implementation of this charter and further promotion thereof. In our opinion, the value of that charter is for the big companies that join the charter to follow the charter conscientiously, and for the principles embodied in the charter to be implemented in real life. One of the key principles contained in the charter, and that few people pay attention to, is that those anti-corruption principles of honest behavior must be shared by all the employees of the companies and promoted in the company. Because the owner of the company and the Director General may speak publicly about how he or she shares the principles of honesty, but on the level of line managers, on the level of rank and file personnel, those practices may be retained, and certainly there is a demand for corruption on the level of private business. Other things that we discuss concerning the charter with our colleagues. 131 companies that joined the charter isn't much, probably, but according to my observation, the companies do study that document seriously, and many of the companies that consider joining the charter think for such a long time, have been thinking for such a long time, because if they join that charter, they will be bearing certain responsibilities for their activities, for their joining that charter, and they try to see how much that charter meets their corporate procedures and whether they can be as transparent as the charter suggests. So we can say those are not empty words, and that charter is really a tool that may be efficient and resultative. The charter has its own website. You can familiarize yourselves with the charter. It also has a special committee, a joint committee of 4 organizations, 4 parent organizations that periodically meet to assess the activities by the companies that consider applications for joining the charter. And the next mechanisms that will start working in the fall, those who were the first to join the charter will be reporting to the joint committee, will be reporting about how successfully they are following the charter, and colleagues periodically raise a question to the authorities about certain legal tools of state support for participating in that charter. So some of the colleagues say, let us provide certain preferences in the law on procurement. So if you join the charter, you will have a better position during a bidding procedure, or you can declare it in your application for the bidding procedure. You can declare that you are an honest and unbribable company. That's a difficult issue, whether this government should create any preferences or any other support to those who have joined the charter. Our response is rather no than yes, because as soon as we start introducing such legal preferences, this will result into what's called certificate training or declaration trading practices. This will turn the declaration of values into something very dubious. So far, we do not share those opinions. Well, our colleagues will be speaking about Article 13.3 of the law that demands setting out programs and measures inside the companies intended to counter corruption. And in the context of Article 28 of the Administrative Code that describes the notion of guilt, in this light, if a company has joined the charter and if any of their employees have been found to be corrupt, one of the elements of proving the innocence of the company may be the fact that the company has joined the charter and that there was no intent. Well, this is an interesting issue. And in conclusion, I would briefly touch upon another issue. This is lobbying. As far as I remember, a special roundtable was dedicated to this subject during the previous forum. It is very widely discussed within two contexts. The first context is setting up a certain professional lobby community. Also, the emphasis is made on lobbying as profession and on the relationship between client and the performer. It comes up even to registering professional lobbyings. The second aspect is related to the negative connotation associated with the word lobbying in the Russian language. Supposing that lobbying means bribing, and supposing that officials act in the interest of some companies because they're motivated illegally, by illegal means. The third aspect, which is rarely discussed, and maybe it is because the word lobbyism or lobbying has a negative meaning in the Russian language, it is that lobbying is a way for the civil servants to find the interests of the stakeholders in the process of decision making. And in that sense, we've have had quite a lot of formalized procedures that include the public councils. We initiated that project, and we think it's a very successful project, which is called a regulatory impact assessment in Europe. And this is a tool involving public hearings and consultations. What's missing, though, is looking for a divide between finding those opinions and their impact on decision-making, including the illegal impact. I remember a case when the notorious law on countering tobacco smoking was passed. And we already had public hearings and public consultations at that moment. You know, tobacco companies are the most artful lobbyists, and they are real professionals, not only because of their motivation, not only because the civil servants are bad, but because they are very clever in motivating their positions. That was a big issue, and the Ministry of Economy had very serious arguments against this law, but the main accent was on the Ministry of Economy preparing comments. So that means they support smoking. It means they have been bribed by those tobacco companies. So it was kind of dangerous for the public officials even to meet representatives of those tobacco companies, because that brought up suspicions of being influenced. So we are proponents of looking at the issue of lobbying in our country in this light, in the light of finding all the opinions, all the needs of the stakeholders, being absolutely transparent, so that the persons who will have to take decisions based on a lot of data will be protected and will be able to work efficiently. Well, that is the end of my speech, meaning that the rigidity of anti-corruption measures must take into account that they should not destimulate honest officials. They must rather do the reverse. Thank you. Well, thank you. I believe this was a very interesting and professional presentation, showing that we've made a lot of way from general slogans of fighting corruption to real implementation. And in some cases, we are even trying to choose the best ways to fight corruption. At the same time, I believe it is the time to give the floor to the speaker speaking on the key issue of our roundtable, and that is how the businesses take measures to counter corruption. In the Russian Federation, it all boils down to this being the function of developing methodology for this, and this methodology is to be developed by the Ministry of Labor. We have Dmitry from the Ministry of Labor, and he will be speaking on this subject.
Thank you very much, Mr. Chairman, and a lot of the speakers had already said during this day that from one side we definitely have a need of improving our anti-corruption measures at the governmental level through introduction of different limitations and through a different system of motivation and stimulation. But on the other hand, we have to develop those mechanisms that will contribute to fighting corruptions in the business environment. Meaning, we need to put measures in place that will help the companies themselves, those who refer to the government for help. I think the next stage in here would be to develop the mechanisms that are there to stimulate the business, so that the business undertakes the necessary measure to counteract corruption. Last year, the Ministry of Labor has prepared recommendations for all businesses functioning in Russia how to apply various anti-corruption measures. These recommendations are based on our law number 1303 on fighting corruption, and it is said there that all organizations must undertake measures to counteract corruption, and there are following activities that are listed in this recommendation. Well, definitely those recommendations might be too detailed, but there are some general ideas as well. And I believe that we must really move forward, and already at the next stage we must try to figure out how these recommendations are going to be implemented. So as for the next step, we believe that there should be two ways to move forward. The first one, we definitely must discuss those anti-corruption mechanisms that are contained within the federal law and the recommendations I was talking about. And we must try to figure out whether these mechanisms are really optimal, really feasible, and what can be improved further on. For example, how to assess corruption risks within an organization. We must review an issue of giving gifts and presents, and we must instill mechanisms that regulate such kind of relations. We must review various contracting mechanisms with subcontractors and other partners, how to regulate conflicts of interests. We definitely must develop a mechanism that will not only look efficient from the outside, but also will really contribute to the overall situation. In the future, we may move on to a different system. We may start developing more detailed procedures and more detailed standards, and these standards and procedures must be inscribed in particular regulations that have to be implemented by various organizations. But just having these standards in place is not enough, because we must also have a number of stimulating measures, the measures that would call the business for putting these measures in place. And also the government or the legislation does not regulate how to monitor implementation of such measures and how organizations are punished for not implementing these measures or penalized. And also, we don't really know whether there are any preferences provided to such organizations that do take on board such measures. And these questions are not only discussed here in Russia and in this particular venue. There are many such kind of debates and discussions. We really must take stock of the best Western experience, have a look at what is done at other countries, and then implement something in here in Russia that will be similar to our specifics. It was said in here that if we introduce preferences for governmental outsourcing, for state purchasing, it would lead to some risks. What can we outline? What measures of stimulating business can there be? First, if the organization is doing some corruption act, we may diminish their liability or cancel it. So if the damage to the public was not excessive, and if the company proves that they have a very good system of preventing corruption or of mitigating corruption, then this company will be given certain preferences, and when such cases are reviewed at courts, these all things can be taken into account. Such a system is very well developed in the USA. For example, there's a regulation about how to put forward penalties to such organizations, and there's a system of points about its if the organization is cooperating with the investigators, then it gets that number of points. If this organization has some system in place to prevent and counteract corruption, then it gets some other points, and then you can compare different organizations between themselves and each other. I'm not calling on us to copy and paste this practice over here. We just need to take into account that such an option is possible, and we might consider it as an option when developing some of our own mechanisms. If we take the EU countries and many other countries like this, there is a mechanism of limiting access of a company to state purchasing, to state outsourcing. So you can limit the company from entering into state tenders for a lifetime or for a certain period, and this may also serve as a stimulus. So the company will never go for it if they really want to still ensure they have an access to governmental money, to the budget, and to state purchasing system. Another possibility is introducing a certification system and organizing an independent and third-party auditing. Such third-party auditing outcomes may be taken into account when dealing with a particular case, if it is so decided, or it can be taken into account on a compulsory basis. And there are different kind of options, and we just need to look which option is more appropriate for us. And there are definitely more other options that we can implement in here, and we can stimulate the business to introduce their own anti-corruption programs. For example, some of these measures might be related to image, to a simple image of the company, or some of these measures may entail certain economic consequences, tax burdens, and so on and so forth. So we can start thinking about this. I believe it is high time we discuss these possibilities of limiting responsibility, limiting access to state purchasing, certification, and so on and so forth. And definitely when it is time to come up with a decision, and definitely this decision would have to be made by all of us, all the stakeholders, the government, the business, and everybody else, we need to take into account our own specificity. Even this limitation of state purchasing, if we do that right now, we understand that maybe some one-day companies will appear, some pocket companies will appear that will try to deviate from this limitation, or that will try to avoid this limitation. Maybe we can introduce this kind of limitation for large purchases, more than 1 million rubles, because these are the kind of deals that hit larger suppliers the most. And I hope that we will be able to establish a very active dialogue, probably using the Ministry of Labor as the venue, in order to continue to discuss those measures that will help us to stimulate business undertake anti-corruption programs. Thank you very much. I think one of the venues for such discussion can be a meeting that we're conducting on the 25th with state corporations. Why I'm talking about this, I'm just trying to fix it in my calendar to know what I have to prepare for, since these topics will be discussed in there. Thank you very much. It's a very interesting question that you've raised in here. It definitely requires practical work, but I would like to note in here that our law on counteracting corruption, this Article 1303, it contains two parts. The first part is more imperative. It says that the organization are required to undertake measures, or must undertake measures. And the second part says that the measures are as follows. There's a column there, and then all those measures are listed. But, as we said, it all depends on the scale of the organization, because from one side you have companies employing just 10 people, and for them you need to use only one set of measures. On the other side, you have organizations with thousands and thousands of people, and definitely a different set of measures can be appropriate for this case. But why I'm thankful to you? Because you have voiced the idea of this differentiated approach, of a different kind of approach. So we must undertake our measures, we must take our measures in a more pointed, poignant, and specific way. Our anti-corruption system must be built in a different way depending on whom you are targeting it to. Dear friends, our roundtable is in the full swing, and all of the speakers have managed to take their floor, but Artur asked me to be the last one during the conference, and that's due to a number of aspects. I know what he's going to talk about. He will be presenting us a very interesting set of data, and I think it will serve as a very good wrap-up. I would like to discuss our future agenda. Now, Mr. Konov will talk. He will talk about training the experts, the people who will be counteracting and fighting corruption. After that, I think we'll give floor and we'll open up floor to everybody who would like to speak, who have this urge to present themselves for 7 to 10 minutes. And after that, we will wrap everything up and we'll give the floor to Artur. I understand that your presentation is ready. Well, this is your decision. I was not hoping to be the last. I just said that I wanted to be somewhere in the end. Okay, if it's okay with you, then we'll give the floor to Alexei. Alexei is representing the Russian Presidential Academy of National Economy and Public Administration. This institution is training experts in anti-corruption. He will talk about that in more detail. Thank you very much, Valentin. Mr. Chairman, good afternoon, dear ladies and gentlemen. I would like to tell you in brief about an aspect that's been touched upon for a couple of times during this day, but it hasn't been investigated at any length yet. To my mind, one of the key mechanisms of introducing effective anti-corruption program is the availability of effective and thorough educational technologies that help to understand what kind of programs do we need to introduce, how they have to be introduced, what the government has to do in here. And these questions of education really become very important when, in a short period of time, you are introducing a whole range of different norms and regulations. And since we are now at the threshold of a new era, when the government pays more attention to anti-corruption, which we didn't have before. This new article has appeared, 1303. There is another article in our civil code dealing with anti-corruption, but they only appeared in May this year. And some of the recommendations also came on board just recently, which Valentin has said. And there are many more ideas. How shall we go and what shall we do in the future? So we're at the threshold of lots and lots of changes, and if everything is okay, if all those measures of stimulating organizations on introducing anti-corruption measures are taken on board, then we're faced with a very serious task: how to explain to business what the government wants from it, how to explain the new rules of the game, and what our business community must do in order to comply with these requirements and new needs. Without those educational programs, without the explanation, without the methodological support, there's a great probability this whole process will be stuck. There will be lots of mistakes, there will be lots of misunderstanding, and we will not be able to jump from where we are. So one of my main theses is, if our government is planning to introduce new regulation in any sphere, it must think first and foremost how the new rules of the game will be explained and how we need to train and to teach everyone about these new standards. And we've already been through it. So we've been there and we've done that. When the new law has been introduced, the anti-corruption law for the governmental sector in 2009-2008, when we got this law on counteracting corruption, and a lot of sub-norms and sub-acts that detailed and explained what the law has to say. And back then, our public officials, our public bodies saw that in half a year lots of rules have changed, for example, how you should declare your profits and so on, and they had to really adjust to the new reality and they had to live with that. But this process was not very easy, and the lack of methodological support, the lack of information was really well perceived back then. So what did we do in order to counteract, to overcome this program? Well, first we organized a special program that we did in our academy, program on preventing and identifying illegal actions in public authorities. This program was aimed at people in the field, the ones who are responsible for regulating all that in the government, in the public authorities, because they also didn't understand what were the new rules. And this program is a regular one. Each year we enroll about 1,500 people in it. Mainly the delegates and the attendees are the representatives of the public authorities. We teach them what is written in the legislation, how to interpret it, how to implement it. And additionally to this educational program, we introduced a number of others. For example, we are having the Train the Trainer program as well, because very often we face a situation that there are not so many people who can teach teachers and train the trainers. We must also have a lot of trainers for our needs, but they are missing. So we've introduced this new program, and we're training the ones who are teaching how to implement the anti-corruption law on practice. If all the measures that were mentioned today are going to be introduced finally about counteracting corruption in business, and if in a very short period of time we're going to change the whole landscape, then probably we would need to do the very same thing for business. And one of the things and one of the ideas that I would like to voice in here is maybe we might introduce the same base program that we did for our governmental delegates, but in this time for business. In private sector, the situation is not that bad as it was in the public sector, because there's plenty of different training programs, educational programs, lots of organizations that provide training services in this area and in this sphere. And without going too much into details, because it will really take a lot of time, but this education is not systemized, meaning that some of the questions are explained in a better way, others being shown away, and probably the American programs are used, and less attention is paid to the Russian norms and rules, so there are some possible drawbacks, but we believe that having this base program for business, everybody will only win, no one will lose. And apart from providing additional competences and skills, this program will also become a very good meeting point, a very good point of attraction for people who are dealing with compliance in business, like it was back in the time when we introduced the same program for the public authorities. Now, let me tell you just in a couple of words about my vision, how this training can look like and what we can do during the training. Today we already see a couple of blocks that can become the part of this curriculum, and these blocks are very often not paid enough attention to. The first block is how to apply Article 13 of Law number 273, Article 19 of Labor Code, paragraph number 28, and we're getting more and more court practice and court rulings, and all these things have to be discussed. All the norms and regulation have to be scrutinized. What kind of measures the companies need to introduce in order to correspond to the new needs, and basically we also have to look at the trends and where this legislation is going. So this block, I think, must be the leading one. The second block, which we cannot do without it, but this block is already very well researched by companies who are providing various educational services, is how to apply foreign law and foreign practices in the Russian in Russian business. This is how to use Foreign Corrupt Policy Act and Bribery Act from the UK and any other similar type of legislation. These laws have extraterritorial jurisdiction, and these laws can be applied to Russian companies and companies operating in Russia. So this is a very important point, and I think that we must pay a lot of attention to it. Now, the third thing and the third block that we must teach our students, and I think we're still lagging behind in here. We need to teach our business about what kind of anti-corruption standards are there for public authorities. So we need to explain the business, what our public authorities and what our public officials cannot do. So we really need to show and shed the light on the system of limitation that our public authorities are faced with, because very often the representatives of commercial companies do not really understand the norms of receiving presents, of giving jobs to former public officials, how this conflict of interest sphere is working. So the representatives of business community do not always know what the public officials are not allowed to do, and it would be better for them to familiarize them with that, because very often, especially with gifts, there are so many situations that people are really surprised to see, and they are really surprised that you cannot do this or you cannot do that. Generally speaking, the public officials cannot do anything, and very many public companies, public officials or governmental bodies even put big signs at the entrance of the building that no presents are allowed or no gifts are allowed, especially close to the Women's Day. Yeah, the Women's Day, the 8th of March, or for example, the New Year's Eve. That's when those signs appear and starts really blaring. It might be a little joke, but still this is true, because very often business does not really know about the rules that already exist for our public officials, and we really need to explain that to them. And there's a whole range of other blocks that we must pay our attention to. Definitely there is a block about legalization of profits and returns from money laundering. 115th The law number 115 have recently been adjusted and amended. April this year, we adopted our national plan on the measures for counteracting tax avoidance and concealing beneficiaries. And we will also be strengthening our legislation on identifying beneficiaries. We took some international liabilities on ourselves. We have a plan that we are going to follow, and that poses a lot of limitations on businesses and companies that we must explain to them, and we must make sure they know and are aware of. And also there is a whole range of other questions and issues. For example, there are some existing measures in place on regulating conflicts of interest. You might not be aware of that, but there's a lot of different measures that we have to regulate the conflict of interest in commercial organizations. We need to say, though, that they're not always put to good use. But, for example, there are special measures for commercial organizations, special measures for pension funds, for pharmaceutical and medical corporations. There's separate measures for auditing organizations, and this list is not even exhaustive. Unfortunately, these norms are discussed only a little and are not explained too often, and maybe this is the reason why they're not put into good use. And also there's our law on shareholders' companies. There is, for example, this concept of a deal with an interested party, and that has not been explained to the businesses as well.
So what can be a basis for further progress in this area is a program which could be envisaged for specifically foreign companies coming to the Russian market, because we must explain to them the essence of the Russian legislation, anti-corruption legislation, because usually they welcome it because there's very little information, and Russian legislation is rarely translated into English. That's the point. Rounding up my presentation, I'd like to say that there's a program, or rather a plan for setting up such programs. Perhaps we will launch one of them this year, and then we will wait and see. Thank you. Thank you. I think that you emphasized quite rightly that we have a systemic approach to counteracting corruption in the Russian Federation. For the lawyers to work, we should do a lot. We should educate people, we should train people, we should set up structures and so on. So, dear friends, we have some minutes to go, and I would like to give the floor to all those present to put questions or comments. Take a microphone, please, for translation. Take a microphone, please. So, I'm involved in anti-corruption activities in Siberia, and a lot is being done counteracting corruption in our organization, which deals with anti-corruption programs. And within the framework of these programs, since 2009, we have been making proposals to the president of our country to create a specialized body which would collect the information on all the activities counteracting corruption. And also it would be controlling the state agencies, because not all the applications or letters to the investigation committee are followed by actions. And the department that was mentioned here, or agency for anti-corruption activities, was set up under the President of the Russian Federation, and I applaud it. Corruption is a very capricious lady. It will be always in the center of attention as long as we have no systemic approach to it. A lot has been said, what should be done, what is being done, which is good, and still corruption is not going to give up. It's parallel to the state power, and it exists thanks to bribery. And what's going on in Ukraine is a reflection of corruption, which is prospering there. And thanks God, we are not going to have it elsewhere. So I propose the following things. We should adopt amendments to the law which was adopted in 2007, Law 273 on counteracting corruption in the Russian Federation. It should be amended and certain provisions should be specified, and 209 law on development business should also be worked out better, because we missed a lot of things here and a lot of details, because it deals with small businesses and it is unprotected in this country and it suffers because of corruptive activities. Another law is a law on judicial community. Raids on enterprises would not be possible if not for the judges who make inappropriate judgments, not complying with law. And those laws which are in effect, they do not affect those judges. The only mechanism is the law on judicial community, which actually is valid and works. All citizens of the Russian Federation, all members of civil society should comply with the legislation of Russian Federation. So from my own experience, I can say that developing programs is of utmost importance for support to financial assistance of civil society organizations involved in anti-corruption activities, because corruption is having an impact on the citizens. The citizens are suffering from corruptive bureaucrats or state officials, public officials, because those citizens who are under court proceedings, they cannot hire a lawyer. He seems to be paralyzed because all the property has been seized. He has no more assets, no money, and so on. We should have a program which should be called Legal Education for Citizens. This is of utmost importance. This is indispensable because legal ignorance is in place. The citizens do not know how they cannot defend their rights. And if such a program comes into existence, we can do our best to make it work. So, also we need another law on parliamentary control. On parliamentary control, because I regret to say that our deputies have no status. They cannot demand an investigation. They can only send a parliamentary request or an application. But whether corpus delicti is there or not, they don't know. So more than 130,000 applications from ordinary citizens were sent to Parliament with complaints. because of corruption in society, which functions on a large scale in societies. Thus, we should join our efforts, all civil servants, parliamentarians, and ordinary citizens, to cope with the problem. Thank you. Colleagues? Very briefly, please. Speak briefly. Do you have a question or a comment? Speak into the microphone, please.
Постарайтесь, пожалуйста, уложиться в 2.
Please cope with 2 or 3 minutes, no more.
Mr. Chairman, thank you very much. I'm presently the Chief Justice of Sri Lanka. Having listened to all of you, I feel encouraged that you are really making a very concerted and a very broadside effort in neutralizing corruption. I merely want to make this observation. It appears that we are all indulging in very complicated mechanisms to tackle corruption at a very high end. But I think it's necessary that we start dealing not with the disease, but perhaps really concentrating on the symptoms. In other words, start tackling the problem at a lower level, where the genesis of the problem is. So I think somebody made the point that we should really concentrate on more education, perhaps at a school level, perhaps at a university level, in our homes, moral education, get to the basics of right and wrong, so that we can teach our children who are to be the future generations, the future people of our countries, what is simply right and wrong, so that they will be inculcated in the values that we can probably, that will ensure that corruption will be tackled. Very briefly, in Sri Lanka, we use the enforcement of strict codes of conduct. We use duties to report on assets and liabilities of all public servants. We use training on corruption-based issues. We even go down to the streets and have little plays showing people what happens when corruption takes place. And we use e-governance in a very large measure, so that you deal with people online rather than deal with people personally. Thank you very much.
Так, коллеги, значит...
Colleagues, 2 minutes each, no more. 2 minutes, no more, please.
Sorry.
Well, just to quickly associate with the comments made by the Honorable Chief Justice, I think the United Nations Convention Against Corruption and the Financial Action Task Force recommendations have provided the map road for fighting corruption. Like in the management of businesses, I think the convention has made it quite clear. So if the Russian authorities will adopt the Financial Action Task Force recommendations with regards to movement of funds, know your customer, how proceeds of corruption are moved about. And I believe if you look at the Financial Action Task Force recommendations very well, I think the way out will be there. This is just my contribution. Thank you.
Спасибо.
You please. Microphone.
Thank you very much. Thank you for such a broad discussion and knowing a lot about especially Russian anti-corruptive system. I'm Nikola Selakovic, Justice Minister of the Republic of Serbia, and I've been enjoying in your discussion, and comparing with my dear colleagues, I would like to ask a question, not to make comments. The issue is so interesting that I think all of us present here in the first and the second part of the session could more exchange our experiences and make so many comments. But when you've been speaking about 2 really important approaches on fight against corruption, the one is prevention, the other one is sanction. I would like to say that also sanctioning, effective sanctioning, can be one of the best ways of prevention. So when you are sanctioning somebody for corruption, it is the best example for everybody what is going to happen with him or her if they are corruptive acting. Therefore, I recognized as a problem throughout many discussions, especially the discussion of Mr. Baker, the discussion of dear Mr. Rodrigo, and the discussion of Mr. Fedorov, that there is a problem in maybe all the system, and also our colleague from Italy, on the education of judicial authorities in fighting against corruption. The corruption is tightly connected with economic crimes and financial crimes if we are talking about high corruption. We are having a problem that our prosecutors, more prosecutors than judges, are not financial experts. Therefore, there are efforts in some of the countries, as in my country, to enter into public prosecutors' offices financial forensical experts to improve the investigation. And when you've said that there is a problem of non-effective process, the process which dures 3, 4, or maybe 10 years, the problem is that prosecutors cannot make their charges as financial experts, and judge is having a problem to make a verdict on the charge which is posed on more legal than legal and financial basis. So my question is, for all the participants, but especially I would like to hear the colleague from Italy, also Mr. Stephen Baker, and Mr. Fedorov, what do you think about this idea to arrange permanently presence of professional financial forensicals within public prosecutor's office? Because without this broadening of scope of our public prosecutor offices, I think that we cannot have the effective act of justice and anti-corruption behavior of the state. Thank you very much.
Mr. Chairman.
Спасибо.
Thank you. Thank you for your question. And very briefly, please, who can answer it? Very briefly. So, prosecutors and investigators should be experts in finances. That's the idea, right?
Yes, it's extremely correct. I think that in the office of a public prosecutor in Milan, this is a tradition. So also public prosecutors are expert in financial. I am a public prosecutor in anti-corruption only from a year. For 10 years, I am in another department. The first department in the office of Milan, and the first department is specialized in financial crimes. In the past, I was involved in Parmalat case or in Anton Veneta case, that is a financial case. So, in my opinion, just a minute. In my opinion, it's very, very important to know the invoice and the accountability. Because from the accountability and from the invoice, you can try bribery. Thanks, Mr. Chairman. my delegation asked me if I can go because I think that there is our vice minister. Can I? Or no?
Конечно, можно. Конечно, можно.
Yes, certainly you can. Yes, why not? Certainly you can. Go, please, leave us.
Interesting for me, but if if it's possible,
Конечно,
Thanks.
of course.
Of course, of course.
И вам спасибо большое за...
Thank you very much for your response. And now, Alexander Fedorov. The question is formulated absolutely correctly. Given the Russian legal system, the investigation of such cases is by the preliminary investigation offices, and investigators do specialize in administrative crime and financial crime. And when we speak about the financial liability or the criminal liability of legal entities, we mean that those experts who are experts in financial matters will assess the actions by the legal entities, which will allow them to keep their specialization. Thank you. I believe that we will have finished this free discussion right now. Thank you for the question. The main answers to the question have been voiced. And now, as we planned, we are giving the floor to the head of the bailiffs service, who has a very interesting presentation, who will be speaking about the compensation for corruption crimes. Really, the service that I'm heading, in the context of today's problem, deals with two issues. I apologize. Yes, there are two issues, main issues for our service, and those are compensation for the damages inflicted by corruption, and also the important kind of punishment, important from the standpoint of corruption, and that is imposing a penalty, a fine. I will provide a few numbers that would confirm to the efficiency of the work that has already been done within the framework of the program already mentioned, including it was mentioned by the speaker already, the counter corruption program. When we speak about incidents of corruption, especially in relationship with the businesses, the corrupt side is always the civil servant. And it's always important to see how the civil servant reacts to corrupt offers. And we have the numbers. In 2008, in the course of the year, it was only once one civil servant reported that he had a corrupt offer. One criminal case was started, and this is all for 2008. In 2013, there were 539 such reports. This proves a colossal growth, and the number of legal actions against people who tried to bribe a bailiff has increased also. One case in 2008 and 178 in 2013. By the middle of this year, we already have 67 such criminal cases. About 15 to 20% of those corrupt offers or bribes came from businesses. The average amount was something like 50,000 rubles. There were even bigger offers, sometimes exceeding 1 million rubles. And those were the attempts to bribe which resulted in criminal cases. This is the statistics that, in my opinion, shows certain results of the work done. So we have really a huge growth in such cases. Now, as for our activities in this area, certainly the first issue is compensation. It's a very difficult task. I can again quote some numbers. During the last 3 years, between 2011 and 2013, we had over 560 proceedings to the total amount of over 2 billion rubles. As of now, we have completed every 6th proceedings. Probably this is not a very small amount, that's over 15%, but it doesn't look that successful if we talk about the amounts. And certainly the proceedings with small damages are more successful. As for big damages, over 2 billion rubles remain unrecovered, and this is a very difficult process because of the absence of assets, the absence of profits, especially with some of the people who have already been convicted and are in prison, but their assets are generally affiliated or simply absent. And what remains important is that we believe the most efficient way to make progress here is to develop legislation that would provide the maximal motivation for a person who has been found of corruption to cooperate with the investigation and with the court by an obvious correlation between the punishment and his actions in recovering the damages. So that means there must be a direct link between the punishment, the final sentence, and the actions by the culprit in order to recover the damages. And also this may be related to a suspended sentence. Obviously, we would like to see a better influence of this measure and better relationship between this measure and the relationship between recovery of damage. Unfortunately, we can't see that so far it influences, those two notions are not too much connected, and because of that, mainly we have the numbers that I quoted in the beginning of my presentation. Now, as for the penalties for corruption, a few years ago our criminal law was substantially changed, and corresponding serious penalties were introduced as a punishment for acts of corruption. Certain problems arose in enforcing those new laws. They were related to the fact that when trying to execute this sort of punishment, we often mixed it up with debt recovery, and that the procedure followed the same way as the recovery of usual civil debts. Because on the one hand, recovery of a civil debt may be difficult for a number of objective and justified reasons, which may lead to freeing the debtor from recovering those debts because of his material position, because of his poor health, because of the absence of assets. And as for the fine or for the penalty, our law enforcement followed that principle, and this actually undermined the principle of irreversibility of punishment, because we had to understand that there's a difference between debt and a penalty. Actually, our law, it was because of our law, because the procedure for fining a person, for imposing a penalty on a person, was not very specific and actually admitted a situation whereby a criminal penalty could be lifted because of certain objective circumstances. We took certain measures during the recent years. In particular, we introduced specialization in this area. All the fines related to corruption were concentrated in specialized offices, typically central offices of the bailiff's service. And jointly with the Ministry of Justice, we initiated amendments to the law, and those amendments clearly explained that you can only cancel a penalty for crime because of certain reasons, and the only reasons were the death of the culprit, or the culprit has to pay the fine, or the fine is replaced with a different punishment. And certainly, what was of importance was the resolution by the plenary session of the criminal court, which defined those principles that I described. It was again pointed out that a criminal fine has to be paid without any it has to be paid or has to be replaced by a different punishment proposed by the bailiff service. We already have certain success, achieved certain success in this area. We've I can quote some more numbers. In the 5 months of this year, the 5 months of this year, we have executed 801 proceedings to the amount of over 600 million rubles, and that's 3 times bigger than during the same period of the last year, and it exceeds 6 times the results for the 6 months of 2013. 695 proceedings ended with paying the fine, and that is also 3 times bigger than during the same period of 2013. And so that means that the measures that were taken during the last 2 years start to yield result. Of course, the law enforcement practice is prone to inertia. We see there are certain problems, but they are being solved. And we hope that this principle or whether you pay the fine or the fine is replaced with a different punishment, will prevail in our practice and in the court practice. Of course, there are exceptions related to some extreme situations where the court allows a grace period for paying the fine, but I should repeat that this should be an exception. And in general, the practice that you can see in the screen and that I talked about must lead to the fact that the fine will be playing its part in preventing corruption. And maybe my next point will be a debatable point, but what I want to say is that it's very important within the framework of the procedures intended to bring corrupt officials to justice is to confiscate those assets that were received in the course of corrupt activity. And a big penalty, a big fine makes the convict to remove those assets from the affiliated arrangements and to return them to the state. But that would only be possible if the punishment is inevitable. So either those assets are turned into money to pay a serious fine, or the sentence is replaced with a prison term. The fine is replaced with a prison term. And like our Serbian colleague said, this practice will seriously prevent the corruption and acts of corruption. Thank you very much. Thank you very much. Not only for your presentation, but for the work you are doing, because I'm well aware of the tasks you are performing. I know that you are making every effort to fulfill the presidential order, and I hope that we will be moving in this direction and we will be more efficient. May I ask you one question? The punishment, the criminal punishment, applies to the criminal. But what do you think about this idea of inheriting the sentence, inheriting the fine, so that if a person doesn't pay the fine, his children and grandchildren will be paying that fine? From the standpoint of punishment, or essence of punishment, I believe this is punishment presumes personal responsibility. We can talk about passing on to the heirs the responsibility of recovering the damage. Maybe this is a field for discussion, because this boils down to the obligation to recover the damage. But as for the criminal punishment, well, you can, if you bring it to the extreme, and maybe this will be a bad joke, but you can actually send the heirs to prison. I'm not talking about capital punishment, of course. This would be too extravagant. But then you can propose that the children, the grandchildren, to go to prison if their grandfather only spent 10 years in prison out of the 50 years before he died. So I'm afraid that as for the criminal punishment, I think this contradicts the very nature of criminal punishment. As for the debts and as for the damages, yes, why not? Why not? At least, certainly you have to work with the assets that remain with the criminal. If quite often, if we have a live person, he doesn't have anything. And when he passes, somehow it turns out there is some sort of heritage abroad and the heirs start to divide. So you have to find that heritage, you have to find that property abroad, and those assets of a convicted person must be used. And we could think of using those assets, if those are assets of a debtor, of these assets may be used to redeem the fine. And I talked about this principle: either you pay or you go to prison, or you are sentenced to some public work. It's not necessarily a matter of going to prison, but you have to talk about the recovery of damage. Maybe yes, why not? Thank you. It is my understanding that you've provided a very comprehensive answer to the question, and as a well-known character in the Russian movie said, the last sentence remains in the memory, and probably it is your presentation that will remain with us. Friends, the laws of any round table are inevitable. That means that any round table comes to an end. I'm very grateful to everyone who participated, especially to the speakers for their bright ideas. Thank you very much for everyone who spoke. A lot of interesting ideas were brought forward, a lot of interesting proposals. Certainly, we will have to take stock of all of those ideas, but when implementing these ideas, you have to bear in mind the resources needed to implement those ideas, the need to prepare for the implementation. Well, looking for property, yes, I understand that, but this involves a whole sphere of activity. The same is true for the laws on SMEs. There's a lot of problems in the field of their relationships with agencies of oversight and the promissory agencies. And we need to combine a whole national plan. And by the way, we have to prioritize what we work on. So certainly some of those ideas will be implemented today, but some will have to be postponed. Allow me to extend my deep gratitude to you, and I hope that we will be meeting more and discussing these things. Thank you, and everything the best.